Um, my co-host there with the other National Property Network background is Dr. David Harwood. David is an HMO specialist and teaches all about the do's and don'ts of what you should do with HMOs. My name's Barry White. I specialise in lease options, and I teach lease options. I'm a property mentor, coach, and as I said, one of the co-hosts of the National Property Network. We started this network group now, how long ago, David? 14 months, something like that?
Yeah.
Just before lockdown, was it, or was it during lockdown? I can't remember.
I think it was just during lockdown.
Primarily to bring people together that we knew and be able to have some special guests on. And those of you that have not been with us for since the start, we've got some quite good previous guests on that are actually on our YouTube channel. So this will be, I'm assuming, will be posted on YouTube. I hope to get a nod from my wife to say that it will. Yeah, she's down there. Yeah. So you can watch previous episodes of this if that's what you want to do. As always, as David said, we've got Wayne Gray, who is a mortgage broker, managing director of DMI Finance. He's also my mortgage broker, and he's on with us every single month, telling us all about what's happening in the property market, the lending market, and who's got the best deals and who hasn't. So that's good. So without further ado, what I'm going to do is I'm going to hand you over to tonight's star of the show, Tessa Shepperson. I came across Tessa because I kept getting emails from her, or from her company, Landlord Law, and I actually opened one of the emails and I thought, wow, what an incredible source of information. Tessa and I have been talking for a few weeks now. I invited her on. She gladly, fortunately for us all, accepted. And here she is. So she's going to take you through a presentation. I'm not going to steal a thunder any more than that. And I'll let you take it away, Tessa. Thank you.
Okay, shall I see if I can share my screen?
Yep.
Okay. Okay, so hopefully you can all
Yeah, we can see that, Tessa.
Excellent. And you can all hear me all right, can you?
Yep.
Yep.
Good. Okay. Right. Well, when Barry got in touch with me, we wondered what I should talk about, and we thought maybe talking about management mistakes that could cost you money might be of interest for people. So I drafted this up looking at 5 areas, quite big areas actually, where if you make a mistake, it can cost you huge sums of money. So let me move this forward. That's me. That is a considerably younger photograph. I've been through about 4 pairs of glasses, if not more, since that photograph was taken. And I think I've been to the hairdressers when that had done. I haven't been to hairdressers for 2 years now, so my hair's looking a bit different. I am a solicitor for my sins, and I specialise in landlord and tenant law. And I run an online, well, I used to run a solicitor's practice, and I specialised in work for landlords. Well, I sort of veered towards working for landlords. And then I set up an online information service. And then I found that I was earning more money from the online information service. So I closed the solicitors' firms down, and I just do that now. And I do training. I develop training courses, and we run events. And the main event that we run every year is the Landlord Law Conference. And the Landlord Law Conference used to be a proper conference. In fact, last year we were due to have it at a lovely hotel just outside Norwich, which is where I live. And of course, the coronavirus came along and we had to change things quickly, and it went online. And it's now an online event. And I'll be telling you more about that later. And I'm also an author and speaker. So that's me. Now, I understand that this group seems to be primarily about the investment side of things, which is not something I really do anything about. My background as a solicitor, as a litigator, not as a conveyancer. But when, you know, all the exciting investment bit is actually, if you're going to hang on to your property for a long time to get capital gain from it, it's just the start of sort of quite a long journey of you as a landlord. And one of the most important things to realise about being a landlord is that you are providing homes for people. You may view it as an investment, but so far as everybody else is concerned, including the authorities, you are providing a consumer service. You are providing a consumer service, providing homes for people. And it is a very heavily regulated area. So we'll have a look at a few of those things. So the first of my 5 things that could cost you money is not protecting your property at the land registry. Now, this is really, really important. If you haven't done this, I suggest you put a big notice on your desk and either do it this evening or first thing tomorrow morning. Because when applications are made for mortgages or to transfer properties, where is the land registry going to send the notification? Are they going to send it to your address, or are they going to send it to the property? Now, if they send it to the property, which happens in a vast number of cases, if your tenant is actually a criminal or fraudster or someone who's looking to, you know, sort of take over your property, all the notifications warning you all that will go to him at the property. It's not going to go to you. And there was a case here, Barclays Bank and Guy, which is where Mr. Guy owned a property and he didn't protect it at the land registry. And fraudsters who rented his property, first of all, they transferred it into his own name. And secondly, they took out a mortgage on the basis of the property. And when Mr. Guy found out about this, they had a big case about it. And the court held that he could transfer the property back into his name. But because at the time the mortgage was taken out, the property had been validly in the name, and so far as he was aware, because you have to accept what the land registry says, the mortgage, the property was in the name of the fraudsters. He couldn't get refunded the mortgage. And that is a really, really worrying case. So there is the link. There is where you need to go. And it is free. You can register your property for free. And if any applications are made to deal with the property, you will be notified. I think you can register up for 10 properties. Could be more, I can't remember. But it is terribly important that you do this. So what happens if you don't? How it's going to cost you money? Fabulous picture there of your money going down the plug hole. So basically you could lose your property and you may find yourself responsible, like Mr. Guy, for paying off a loan where you haven't had the money. So please, please do that. So that's my first point. My second point, David's already mentioned this briefly. You need to get your property in good nick. And there are an enormous number of regulations and acts of parliament that deal with this. The area of law relating to keeping rented properties in repair is, I have to say, unnecessarily complex. I'll go through these briefly here. The landlord and repairing obligations, they are set out in section 11 of the Landlord and Tenant Act 1985, and they apply to all tenancies with a term of, I think it's less than 7 years, or it could be 7 years or under. It's one of the two. I can never remember which one it is. So under those regulations, you are responsible for keeping in repair the structure and exterior of the property and the installations for the supply of electricity, gas, sanitation, water, and space and water heating. So the boiler, for example. You can't put those, you can't make the tenant responsible for those. So if you've got a clause in your tenancy agreement that says, you know, that the tenant will be responsible for keeping the roof in repair, or the tenant will be responsible for keeping the gutters in repair, that would be void, because you can't do that. The legislation says that that it's not something that can be excluded unless you get an order of the court. It does provide that if you make an application to the county court, the judge has the power to make an order excluding that. I have never ever known anybody do that, and I doubt whether the judge would make the order anyway. So that's that. Now, the trouble about the repairing obligations from the tenant's point of view is that you're responsible if things are broken, but not if they're rubbish. So if a window is broken, you're responsible for putting it in repair. However, if it's always been drafty and it's not double glazed, the tenant can't make an application to court for you to upgrade it and double glaze it. Under the repairing obligations, you only have to keep things in repair. And a lot of tenants complained about that. And so a recent legislation that's been brought in is fitness for habitation. And under this legislation, a tenant can also bring a claim if a property is not fit for habitation. Now, probably most of you won't need to worry about this, because for a property to be unfit for habitation, the problems need to be quite serious. It's not going to be a crack in the window. It's going to be holes in the roof, and, you know, broken and banisters missing, things like that. But you need to be aware of it. And it came into force. I think it was a couple of years ago it came into force, because it's been around for a while. So those are the two main acts. Then there are quite a few sets of regulations regarding utilities. You're probably all aware of the gas regulations, or I hope you are. And under the gas regulations, you have to have the property inspected by a gas safe registered gas installer every year, and certainly before the property is let. And you have to give a copy of the certificate to the tenant before they move in, and every year thereafter. And the only excuse not to do that is if the tenant won't let you in. And if the tenant doesn't let you in, the health and safety executive, who are the organisation that police these regulations, say on their website that they would accept that. If the landlord's made 3 attempts to go in and the tenant hasn't let them in, they will accept that. But you need to document it. You need to keep records of the letters that you've sent, texts that you sent to the tenant. You know, I'm coming round, we've made an appointment, please contact me. You have to do that. And, you know, you should really keep contacting them every now and again, because, you know, gas, it's probably one of the most dangerous things. I mean, you can blow up an entire street, and it's a killer. You know, tenants have died through defective gas installations. So it is really, really important that that's done. The other one, the electricity regulations. I mean, dodgy electrical wiring is also very dangerous. I mean, I think it's a major cause of fires. The regulations have come until fairly recently. I wouldn't say there were no regulations at all about electricity, because it comes under the landlord's repairing covenants, because you have to keep and repair the installations for the supply of electricity. And the housing health and safety rating system, bit of a tongue twister, does provide for which are the standards which local authorities apply when they are assessing properties if tenants complain, and they can serve improvement notices if you aren't compliant with them. So I wouldn't say there's never, and there's also other regulations, like, you know, there's regulations about the cookers and plugs and sockets and things. But we do now have the electrical regulations, where you have to have an electrical inspection done at least every 5 years. It may not need to be quite so frequent if your installer says so. And it needs to, I'm not, I have to say, as a solicitor who isn't an electrician, I'm not hugely good on the detail of the precise electrical wiring regulations. You know, it is all out there, and if anybody needs info, I'm sure you will far more up on it than I am, but there is some government guidance on it. If you do a search on the internet, gov.uk, electrical regulations guidance, you should find it. Then there's the minimum energy efficiency standards, and all properties now need to have an energy efficiency rating E. And I understand that at some stage in the future, it's going to go up to C. We don't know when exactly, but the government has said that they want to do that. So hopefully all of your properties are E or above, otherwise you can be fined. And you also need to have smoke and CO alarms. The smoke alarms, you need to have one on every floor where there are people living, and CO alarms is in every room where there is a solid fuel burning stove. Strangely, it doesn't have to go into a room where there's an oil heater. It has to be solid fuel, which is a bit weird, but there you go. So that's a brief introduction. I hope that that's just reminding you, and you know all of those things already. If you don't comply with those, you could be sued by your tenants for compensation, and also for an order that you get the repair work done. The local authority have the right to come along and inspect the property, and they could serve an improvement notice on you. If you fail to comply with the improvement notice, you can be fined. You can have a penalty notice served on you, which can be up to 30,000 per item. It's not just for everything. I think it's per item, so it can be very expensive. Or you could be prosecuted. Fines are unlimited in magistrates' courts now. If you are prosecuted in the magistrates' courts and the prosecution is successful, it is then possible for I haven't put that down there because I don't think it happens very often, but it is then possible for the local authority to apply for a banning order. But there haven't been many banning orders made, but technically it's possible.
Thank you.
So somebody's not muted, so maybe if you could mute yourself. So that's to do with the condition of the property.
Great, thank you.
The third one is another one which I would hope very much that you are aware of, is that you need to check your tenants very carefully. And this is even more important at the moment. It makes my blood run cold when I read about landlords who just accept people who just pitch up and say they'd like a property, or somebody recommended by Joe down the pub. You know, I mean, that's no guarantee that they're going to be a good tenant. You really need to be very, very careful indeed who you let in. You need to take full details from them. I mean, it's best to have a form. I mean, we've got a form on landlord law for my landlord law members, but I actually say to my landlord law members that should really be the starting point, and you should develop your own form, because, you know, there may be things that you discover you want to ask people, perhaps things relevant to your particular property, but you need to get them to fill in a form. You need to double check all information. It's really best when you're checking out tenants, and this sounds horrible, but it's really best if you assume that everything's a lie unless it's been independently verified. So if they put a telephone number for their employer, how do you know that that telephone number is not a telephone number of their mate who is primed to give a good report? So you need to go on the internet, or I mean, we used to look in Yellow Pages. That's a long time ago, isn't it? But you need to find the employer and independently check that that is the right telephone number. So double check everything. You take references, personal references. Again, I mean, that depends on who it is, really. I mean, if it's a solicitor or you know, somebody very reputable, then that's pretty good for a reference. Their friend down the pub, perhaps less so. Bank reference is not terribly informative, but at least it confirms that they have actually got a bank account. Employer's reference is particularly important because that's what's going to pay your rent. And previous landlord. If they are a bad tenant, the current landlords reference may be slightly suspect because they may be desperate to get rid of them. So it may be a good idea to go back one landlord and speak to an earlier landlord as well. And sometimes it's a good idea to talk to people on the phone, because sometimes you can tell a lot from people's voices, and they may say things on the phone that they wouldn't put in a letter. But do follow up references. You need to get a credit check report. You want to make sure they're not being followed around by a trail of county court judgments. But you need to be careful with them. Don't accept them as being absolutely right. Do your own checks as well. I think it's also a good idea to check them out on social media. Contrary to what people think, it's not contrary to the data protection to go and do a search on someone on social media. If people want to keep things private, there are ways that they can keep it private. If they've chosen not to keep their entries on social media private, then there isn't a problem with you going and looking at it. So if your applicant says he has no dogs, and you go on Facebook and you find his Facebook page and you see pictures of him and his partner and their 2 Alsatian dogs, that might make you question what he said. Although, of course, you always need to make sure that it is actually the right person, because there's a lot of people with similar names on social media. So you do need to be sure about that. Mm. But putting someone's name into Google, into Twitter, into LinkedIn, you never know what's going to turn up. Always a good idea. You need to watch out for criminals and fraudsters, because they are around. People tend to think that cannabis farms are not going to happen to them, but they could do. There are an awful lot of cannabis farms around. I've got a friend in London who's a tenant, he does a lot of work for local authorities, going out and inspecting. He's found hundreds of them, hundreds and hundreds of cannabis farms. One of the signs of someone who wants to use your property for an illegal purpose is that they offer to pay cash up front, often quite large amounts. And landlords often think, oh, great, you know, they're going to pay the whole year up front in cash. That's brilliant. And I don't need to go around and inspect the property either. Why should I? They've shown their good fides by paying me all this money. But often the reason for that is they don't want you to go around there, and then they're going to hack the place around, stick all the ventilation tubes in, and grow fat cannabis plants there. So be careful. You also need to be wary of desperate applicants, people who say that they're absolutely desperate for accommodation, and can you please let them in quickly without doing the normal checks. These people normally turn out to be total nightmare tenants. When I did eviction work, there were quite a few where the landlord said to me, well, I wasn't sure about them, but they were really desperate, and I felt sorry for them. You know, because you're going to be stuck with them then. I mean, as a landlord, it's not really your duty to house the homeless. It's your duty to, you know, run your renting business properly and make sure that, you know, you have decent people in there. So, I mean, desperate applicants may be all right, but they're just going to have to wait until you've done your checking. You know, and if they don't want to wait, they'll have to go elsewhere. Make sure that you do all your checks, and don't allow them to persuade you otherwise. Take your time and think about it, and trust your instincts. Because if you are in contact with the public a lot, and you've seen a lot of, particularly if you've seen a lot of tenants come and go, and you've seen good tenants and you've seen bad tenants, you'll probably get the gut feelings often for what people are like, and you need to take note of what your gut feeling is telling you, because it's often right. So be very, very careful who you let in. And here's the costing slide. If they don't pay their rent, it could take you now up to 18 months to evict them. If they stop paying rent now, by the time you get them out, there could be arrears of 18 months or more, could even be more than that, because the courts are so clogged up with eviction cases, because they haven't been able to go through, you know, there's been all this moratoria. So that's probably the main reason why you need to be particularly careful. So you could lose the unpaid rent, you've got the cost of eviction, and then again, if you let to criminals, you know, you could either you could lose your property entirely if you haven't protected it at the land registry, as I discussed in the first item, or it could be used for cannabis farm, or there are other illegal purposes. I mean, my friend Ben in London says he's found places where they've, you know, they have illegal sort of telesales, cold, you know, calling places there. They sort of keep trafficked people there. You know, there's all sorts of horrible things. You don't want it happening in your property. So be very careful about the tenant. And also, I suppose another thing about the tenant is you want someone you can get on with, because the tenant, even if a tenant is someone who's going to pay the rent, if they're a really awkward, difficult person to get on with, you may actually prefer to go with somebody else who's not going to be quite so awkward and difficult. There are some people who've got chips on their shoulders and are awkward customers. You know, you're entitled to choose the tenant you like. You don't have to accept the first one. And it's best not to accept the first one and wait and get someone good. Item 4, letting to sharers. Now, there are an awful lot of houses of multiple occupation around at the moment, and a lot of the landlords who of HMO properties don't actually realise that they are HMO properties. Now, a property will be a house in multiple occupation if there are 3 or more people who are not in the same household. And a household really equates to family. So if they're a couple cohabiting, if they're a couple with children, it can be a same-sex couple as well, they are one household. If the household has someone who's an employee there, like, you know, if they've got an au pair there, that they'll be part of their household. They won't be part of their household though if they take in a lodger. So if you've got 3 people, or even 2 people living in a property and they take in a lodger, that will immediately turn it into an HMO. So there are an awful lot of properties that are HMOs. Now, a lot of HMOs don't need to be licensed. There are special regulations that apply to HMOs, the management regulations, and you'll need to comply with those and know about them. But many HMOs don't need to be licensed. Mandatory licensing is you've got 5 or more people from 2 or more households. And that is where the mandatory licensing, if that's the situation, you've got to get a license from the council and comply with any requirements that they may impose. Some councils, not all of them, some councils have additional and selective licensing schemes. Additional licensing is where it's not always throughout the whole of the council area. Sometimes it's just for specific wards. They may require HMOs with less than 5 people there to get a license as well. And this is often in areas where they've had a lot of problems with HMOs, sort of low down market HMOs causing a lot of problems. Selective licensing is where everybody has to be licensed, whether they're an HMO or not. And the only way that you can find out if the area where your property is subject to additional selective licenses is ask the council. So I've put the link here for a Find Local Council, which is a page on the government website where you can locate your local council, and you need to either go on their website or ring them up and ask them. For my landlord law members, we now have a local authority directory where we put a lot of contact information, and I have an assistant, Mark, who has been updating it and putting information about whether local authorities have selected licensing schemes or not. But you can find it out from the local authority. But do check, because if somebody on the other side of the road tells you there's no licensing here, and the boundary for a ward goes through the road, it may be that yours does, even if theirs doesn't. So not having an HMO license can cost you serious money. First of all, local authorities can issue penalty notices of up to £30,000, or they can prosecute. Your tenants or the local authority, if the tenants are on benefit, can apply to the first tier tribunal, FTT stands for first tier tribunal, for a rent repayment order. And a rent repayment order will normally be for up to 12 months rent. And there have been quite a few interesting cases on rent repayment orders recently. And one of them said that it's a strict liability offence. It doesn't matter that you don't realise that you need to have an HMO licence. Ignorance is no defence. If you've got 5 or more people there in 2 or more households, even if you didn't realise that you had to licence it, you're subject to the penalties. Now, sometimes when you are talking to local authorities about your licence and you say to the local authority, look, you know, I'm going for a bit of a bad time, can you give me a bit of slack, allow me a bit of extra time to get my HMO licence, and they say yes, you need to be really careful about that, because although that may bind the local authority, it's not going to bind your tenants. So if the local authority has said, yeah, that's all right, Fred, you know, I'll give you another 6 months for you to, you know, get the property in condition. But you've got tenants in there, and the number of tenants make it an HMO. The tenants can still apply for the rent repayment order. They're not bound by any agreement you've reached with the local authority. So you need to be very careful about that. Rent repayment orders are getting better and better known. And there have been some cases now where there's some very large orders have been made. I mean, if you think of 12 months rent, 12 months rent for all the people in your HMO, that's a substantial chunk of cash. So you really don't want it happening to you. HMO licensing is a big deal. You really need to know whether your property needs an HMO license and then get it. And I mean, there's a lot of things I could say about applications. You know, you need to have proof that you've delivered it because the local authority might lose it. You have to do it properly. Often there's arguments about the plans. It's often a good idea to get proper plans. You know, make sure that it gets in time, answer all the questions. You know, there's a lot of stuff. I mean, we do have on landlord law, we have a lot of stuff on HMOs. One of the things we had, there's a solicitor called David Smith, who some of you may know of. He's a partner at JMW Solicitors, and he used to be at Anthony Gold. And he's a bit of an expert on HMO law. And there are 2 courses I've got for landlord law members. One of them is an HMO workshop, which we filmed, which was done a couple of years ago, which has been divided up into little film clips, which people can watch. And then also last year, we did an HMO day, where David did the talk on management regulations, but we also had we had David Beach from Waltham Forest Local Authority. We had various other solicitors. We had a couple of barristers, all talking about different aspects of HMO. So if you are an HMO landlord, you want to learn more about it, those are available to, there's 2 levels of landlord law membership. For the upper level, the business level membership. But I mean, it's worth doing. With these things, with these rules and regulations, there is actually only 100% protection that you can get from these regulations, and that's 100% compliance. If you comply, you're safe. No one can touch you. You're fine. But you need to know what you've got to do, and you've got to make sure you do it. So, number 5. Number 5 is something that is very unpopular with landlords, and which a lot of landlords have heaved a huge sigh of relief over the past year and said, "Phew, thank God, I've got a great excuse not to do them," and that's carrying out inspection visits. I happen to think that inspection visits are really, really important. And so do many landlord insurers, because you may find that it's a condition of your insurance policy that you have to do regular inspections. I think in Alan Boswell, I think it is, and I think Hamilton Fraser, because I've spoken to both of them. And there will be other insurers. They will require you to carry out regular inspections. Ideally, it should be done every 3 months. The things that you need to check, first of all, obviously you need to check the condition of the property to make sure that you're complying with your regulations, which I've discussed already. And also, of course, if something is problematic and it's left unattended, it's only going to get worse and it's going to be more expensive for you to repair. So it's best to get onto it quickly. You also need to make sure that there's no one unauthorized living at the property. Now, in these difficult times where people are very hard up, it is understandable that, you know, friends sharing in a property or a family may want to take in a lodger to help them pay the rent. But as I've said earlier, that will immediately turn the property into an HMO, may turn it into a licensable HMO. And if you don't know about it, and if the council finds out about it before you do, you could be in big trouble. So you really need to make sure that there isn't anybody living at the property who's not supposed to be there. Your tenancy agreement can help here as well. Our landlord law tenancy agreements are very sort of tight on this, you know, and also to help you comply with the rent to rent regulations. You know, we set out the names of the tenants. We also set out the names and details of everybody else who's living there, who's called household members. And then you say specifically, but nobody other than the named members can live there, and there cannot be more than X occupants at any one time. And X is the total of the household members and the tenants. If you have that in your tenancy agreement, you may find if someone moves in, the local authority come down on you, you may be able to say, look, you know, they are there against my, you know, they're in breach of the terms of their tenancy agreement by doing this. And the local authority may give you time to get them out because it's not really your fault. But it's best to pick up on it and get them to go as soon as possible. Again, you need to check that there's no illegal activity. Now, cannabis farming need not necessarily be the whole property. Some of your tenants may have a nice little earner by growing some in a cupboard or possibly in the loft, which is why, sadly, it's a good idea for you to, you know, poke your head up in the loft and have a look in the cupboard just to make sure they're not doing that. There is an article I read a while from our local paper where someone was growing cannabis palms in a cupboard and they got an income of 13,000 a year from that, which is quite a lot of money. So it's worthwhile people doing that, but you can't allow it because if you permit it, you're making yourself legally liable. You can be prosecuted if you've knowingly permitted it along with the tenants. So you can't allow it to happen. So you need to check there's no illegal activity. In fact, when I was talking earlier about choosing tenants, if there's somebody dodgy, if you make it absolutely clear that you always do regular inspections, that could actually scare them off because they won't want that to happen. They want people who are never going to inspect the property. You also want to get to know your tenants. I mean, sometimes you learn things. You might learn, for example, that Fred Smith is being moved up to Scotland for his job and he's going to be moving out in 3 months' time. He may not have bothered to tell you. So you can learn all sorts of things from that. Now, coronavirus, obviously we have had the coronavirus and, you know, there's still problems about going into other people's houses. You need to follow the rules. You need to practice social distancing. You need to be masked. And particularly now the weather's getting better, I would suggest that all windows and doors are open because we understand that the infection tends to be, what we're learning is it's less by touching surfaces and it's more by the virus in the air. So having good ventilation is good. So if you make sure all the windows are open when you're there, so there's good current of air, it's going to be less dangerous. If you can't go in, there's no harm in going and doing an exterior inspection because you may be able to pick up quite a bit from that. I mean, maybe you can do, I mean, the trouble is landlords don't like doing inspections because they feel it's intrusive. Tenants don't like inspections because it is intrusive and they feel the landlord's coming around and spying on them. And I quite understand, it's a thoroughly unpopular occupation. Everybody hates it, but it's really important that you do it. And you can follow the precautions. How it can cost you money: insurers may refuse to accept claims if you haven't carried out inspections. In fact, if your tenants move out and you go and you find that they've converted into a cannabis farm, if you haven't done proper checking and if you haven't done any inspections, your insurance company, even if you are insured for it, are probably going to refuse the claim. I mean, why should they? You've been asking for it. So that's one very big reason to. And if your tenants are annoyed about you doing inspections, you can always say, look, I'm really sorry to bother you, but it's a requirement of my insurance policy. That's a good excuse that you can give to do it. If unauthorised occupiers make the property into an HMO, you may be fined for not having a licence. Cannabis farming, make it very expensive. I mean, I was talking to an insurer and they said one of the biggest claims they'd ever had was 80 grand for repairing a property that had been converted to a cannabis farm. They did actually accept that claim. That was Alan Boswell, if you want to go to a firm that has been known to accept claims for that. Now, I have done a kit, but it's the most popular kit I've ever done, actually. I've done a kit which I wrote about property inspections, and it's a guide for property inspections, and it tells you, but it goes through the reasons why in more detail than I've done. It sort of gives you a plan to follow with letters that you can send to the tenants, and there's lots of forms for you to fill in while you're there, and there's sort of lists of things that you want to check. And after I first launched, I launched this as what I call a beta product, and it was sold for a short period and then taken off the market. And then I asked everybody who bought it to fill in a feedback form and give me feedback. I had such a lot of feedback. I had the most brilliant feedback from the landlords who bought it, which was so helpful. So the kit has now been updated with most, I mean, I couldn't include everything, it would have made it too long, but it really helped. So there's been a lot of practical input in that kit from landlords with the problems that they've had. So there's a link to where that is. Or if you go to Landlord Law and go to the Landlord Law shop, you'll find it there. So it's really important that you keep up to date. Laws and regulations change. Ignorance of the law is no defence. The penalties for non-compliance can be very severe. And also, using agents won't defend you. The agent probably won't be liable, and you will, even if it's the agent's fault that the problems have occurred. Owning through a company for many things is no defence. I mean, there have been cases, and also subletting on a rent-to-rent arrangement may not protect you. Certainly there have been cases on both of those on HMO licensing cases. So rent repayment orders. So you may not be protected. So you do need to be very, very careful. So how can you keep up to date? Well, obviously the Landlord Law Conference, which is our online event that's coming up in May. And it's a law conference, so it focuses on legal things. We don't have people doing motivational talks or anything. It's all lawyers, mostly barristers and solicitors. They're good speakers, they're not boring. And we've got a couple of Q&A sessions for people to ask their questions. If you want CPD, there's 5-hour CPD. And if you can't attend all the talks, not a problem, because we record them all and you get access for the following 3 months. So if you go Landlord Law Conference, you can read all about that. And there's a lot of stuff there. There's also my Landlord Law membership site, where I've got a huge, I mean, I've been running Landlord Law since 2001. So it's nearly 20 years because it started up November 2001. I had a membership site before anybody knew what membership sites were. And it's got an awful lot of content. I answer questions in the forum. I know a lot of people, particularly letting agents, actually find that particularly helpful. We've got our own tenancy agreements, there's receipts. We do a monthly training webinar, which is very popular. The one we've got coming up next is with a chap called Dave Prinsett, and he's going to be talking about green initiatives, because we've lost the green initiative, haven't we? Because the government's dumped the green grants thing, but he's going to be discussing that. And also there are a certain amount of training courses included in your membership. So if you go to landlordlaw.co.uk, you'll find out about that. And here are some more resources for you. I send out a bulletin every Tuesday. I think that may have been the one that Barry opened up by mistake and then found he liked it. And if you sign up to our mailing list, you can have a free ebook. I have to say I wrote it before COVID, so it's totally COVID free. It's a pre-COVID book, but it is free. My Landlord Law blog, where I write about. We've got our YouTube channel. We've got lots of clips and talks there. We are actually doing a series of webinars every Thursday at the moment, which are free. We've got one on data protection with David Smith tomorrow, and then next week is the last one with David Cox. But I've loaded all of the past ones up onto our YouTube channel, so you can watch them all there. And that's where you can see some free resources that we have, because although Landlord Law is a paid site, we do have some free stuff as well. So, I've given a PDF of this PowerPoint to Barry, but if anybody wants it, they can email me and I'll send it to you. So any questions?
Just while we're getting those questions in, Tessa, guys, I will send out, or Jeanette will, send out the PDF of the presentation that Tessa's just gone through. So don't worry about the fact if you haven't got any links or anything like that, you'll be able to pick them up off that. We'll get that sent out to you in the next sort of 24 hours. And by the end of the week, by the end of Friday, we will also get the recording onto YouTube, onto the private YouTube channel that you will have access to. So don't worry about that. We can, if you've missed anything, if you're coming to the presentation late, don't worry about that. I've got kind of got a sneaking suspicion that we might have a few COVID eviction questions.
Yeah.
But first one from Mika. If the tenant is not paying rent, how many reminders letters should you send evidence before applying to court under a section 21 or section 8?
Well, it's not mandatory to send reminder letters. I mean, I suggest you send one or two, but I mean, it's not written in tablets of stone that you've got to serve a particular number of letters. You've got to make sure your section 21 notice is correctly drafted. The notice period is still 6 months at the moment. Actually, if I can just mention something here, Barry, with our training webinars, in February, we had a training webinar for a lady called Julie Ford, and she's amazing. And what she specialises in is helping to find grant aid and helping support tenants to pay off their rent arrears and support them paying rent. So she'll sort of, I mean, if she's had a case referred to her, she'll check that they're getting the correct benefit. She'll see if she can find grants to help them with their utility bills. There's sources, there's free sources for grant aid, and she can go around, and often she's found lots of different grants which together will be sufficient to pay someone's arrears. And then perhaps if they haven't had a council tax rebate, or if they that will help pay off the arrears, and she'll be able to do things to enable them to get into a proper position so they can stay at the property. And we were all sort of blown away by this talk. And I went to Julie afterwards and I said, look, Julie, you know, you can't single-handedly help all the 500,000 or so tenants who are in rent arrears. How about you and I do a kit? And we've been working on a kit, and it's just about finished. She confirmed to me today that she was happy with it the way it is. And I'm probably going to be launching it next week. And this will be a kit which will guide you through Julie's process in how she is able to source grant and other aid to help tenants, because it's much better to get someone to pay you than it is to evict them. Because as soon as you're going to evict someone, they stop paying immediately, and you've got massive loss. And then, you know, you've got the cost of the eviction, and then you've got to find a new tenant when they go. So I'm very excited about this kit. I think it's one of the best things I've done, actually, or the most sort of meritorious things. So I will be announcing it probably next week. If you sign up to the mailing list, you'll be notified. I'm only going to sell it to my mailing list to start with, because we're going to do it as a beta launch and get feedback on it and then improve it. It's going to be on sale at a discount to start with. So yeah, I can't give you the sales page at the moment, but it'll probably go online next week.
Okay, I think we discussed that last week actually when we spoke, right?
Yeah.
Quite interesting that. Yeah. Okay, let's have a look. Which house would you recommend any particular house insurance companies?
Well, I am an introducer for Allen Boswell. Allen Boswell they specialise in landlord insurance, and they provide landlord insurance for a lot of landlord associations. If you go to the Landlord Law Blog, www.landlordlawblog.co.uk, you will find in the sidebar there an icon or a link for a mini course, an insurance mini course, which I did in consultation with Allen Boswell. I had done, I mean, what we did is I interviewed them and I recorded the interviews, and I had about 3 hours worth of interviews with them. And then I went back and asked them questions, and we put together this this course about insurance. And I suggest you look at it because it's very informative. Some of the way the insurers do things, I found it very counterintuitive. It took me quite a while to get a hang of some of the ways that they, some of the ways they calculate the awards that they do. It seemed very strange to me. So if you look at that, there's a free mini course there that you can look at, which I think is very useful. And there's links there to sign up to Allen Boswell, and I do get a commission, I have to say, from the people who sign up through that. You don't have to if you don't want to. If you hate me and don't want me to get a commission, I'm sure you can do it some other way.
Nobody hates you, Tessa.
But it's very nice if you would.
Okay.
Houghton Fraser also do good insurance as well.
Yeah. Okay. Next question then. If a landlord has not issued an EPC with each AST, yeah, sound like line of duty at the moment.
Yeah.
Is the landlord really facing a £30,000 fine and repayment of 12 months of rent for every tenant?
It depends. I think it's impossible to say for sure, because it depends on how active your local authority are on enforcement. And we have to bear in mind that local authorities' resources have been cut to the bone. I mean, there were private sector tenant departments that had about 12 officers that are now cut down to one man and his dog, basically. So there is a limit to how much enforcement work they can do. So, you may get away with it. You can't count on it, but you may get away with it. Also, as I say, they don't like doing prosecutions because it's a lot of paperwork.
Yeah. But equally, it might be a damned if you do, if you're damned if you don't there, because a lot of the local authorities, right, will see that £30,000 as an income stream.
That's right, yes. If they're using the penalty notice, if they've gone through a certain procedure that they have to go through, they can keep it.
Yeah.
I mean, if you haven't served something, make sure you serve it as soon as possible. I mean, if you haven't served it before, if you haven't served the EPC before they've moved in and you serve it sort of 3 weeks afterwards, the local authority may let you off because you have actually served it. I mean, it depends on the individual officer. I don't think there's one rule for everyone. If you want to check out the guidance, there is always government guidance on the gov.uk, which is where the local authorities would go. I think if you haven't served an EPC, I think it's a £200 fine, or it used to be. I don't think it's 30,000. I don't think you get slapped for 30.
Tessa, it is £200, and the other thing, it would only be up to £30,000. It wouldn't be a straight £30,000.
Yeah, that would be most unfair.
Yeah, and a lot of local authorities are beginning to publish their what's it called? You mentioned it a few minutes ago. Their notice scheme, where they can their penalty charge notice scheme. Yeah. There'll be an initial, and then what happens if you then continually repeat. But a lot of our local authorities haven't, although they can serve these penalty charge notices, they actually know what the charges are that they're going that they're going to give you. They haven't sort of worked it out yet.
There's a lot of ignorance in local authorities, which isn't really their fault because they haven't had the funding to do proper training.
No.
Okay, if somehow a tenant doesn't go out after we say that we need the house to be empty for some reason, what should we do?
Well, pray to your gods. There are only two ways that you can legally recover vacant possession of property. One of them is by the tenants going out voluntarily. The other one is by a county court bailiff or high court enforcement officer acting under the authority of a court order for possession. Okay, so if they don't move out voluntarily, you've got the order for possession. Now, you may want to try and persuade them. You may be able to buy them out. Don't give them the money until they've actually moved out, if you do that. But those are your options. If you do anything else, if you move them out, if you change the locks when they're out, you know, they can sue you for large sums of compensation. Don't do it. That's the answer. I'm sorry, it's not the answer you wanted.
That's all right. Okay, some of these questions are not really for Tessa, I guess.
Yeah, don't ask me about investment. I haven't got a clue.
No, right, okay. Is it obligatory to get references, passport, etc., from a fill-in sharer who has moved into the house early, unexpectedly, to cover the rent of someone who has left?
You need to do rent-to-rent checks on everyone living there. So it's not just tenants, or it's not just licensees if you let your property under a license. It has to be everyone. And the right to rent checks, I mean, they're a total nightmare. I mean, it's been established because they've been challenged for being discriminatory. There have been legislation, the Joint Council for the Welfare of Immigrants, I think they're called, and the Residential Landlord Association supported them, brought judicial review against the government, challenging the legislation because it's discriminatory, it encourages discrimination. And the court accepted that it discouraged discrimination, but they said that it was the sort of thing that government are entitled to allow. So I think that it may go up to the Supreme Court. But you have got to check all occupiers, whether they're a tenant or whether they're just living there, unless they're under 18, but get proof of age because, you know, it's difficult to tell how old kids are sometimes. You need to prove that they have the right to rent in the UK. So normally that's a passport. But there are various other documents that you can check. I don't sort of tell people in detail what they have to do because I think the best thing that you can do is go to the government site. There's a lot of very good guidance on the gov.uk website. If you do go to the gov.uk website and do a search on right to rent, you'll find all their guidance. And they do have lists of all the documents that you need to check with pictures of them. So go there. But yes, you need to check people before they go in.
Yeah, every single one, guys. And I think when they brought it in, what would it have been now? 4 or 5 years ago? They brought right to renting. The
year 2014 springs into my head.
Yeah.
Because they bought it in a certain area, Dudley and various other places. They bought it in as a pilot. I understand that at the time, the Tories were desperate to get this legislation in because, you know, they wanted to stop illegal immigrants, and the Liberal Democrats who were in what was the word? They were in the coalition at that time, and they persuaded them to do a pilot. But when the pilot came to an end, it was the end of the coalition. Tories were in on their own, and I don't think they even considered the pilot. They just brought it in for everybody, and it's a total nightmare scheme. Hardly anybody has been deported because of it.
Yeah,
it just causes enormous inconvenience for everybody, and of course it's dreadful for people who are immigrants or even just, you know, look foreign, because landlords, if you breach the rules, you could be sent to prison and fined £3,000. So, you know, landlords are very risk averse. Obviously, they're probably going to try and rent to people who've got British passports, so they're safe.
We've been saying from day one, and David and I were training together when this first came in, I believe, that you all of us overnight, every landlord in the country became an immigration officer.
I know, it's outrageous.
And we were saying that everybody needs to be checked, regardless of race, colour or creed, right? Sort of white, English, Welsh accented people should be checked.
Even your mother.
Yeah.
The only time you don't actually need to do it in a subletting situation, provided you make it clear in the agreement for subletting who is responsible for it, but someone's got to do it. So either you as the head landlord or the sort of middle landlord. If it's a rent to rent agreement, you need to work out who's going to do the right to rent checks.
Okay, here's an interesting question. Tenancies obtained by deception, how would the eviction work?
Probably with great difficulty, and quite frankly, I wouldn't bother. I'd go under Section 21. When you bring a claim for eviction through the courts, you have to have a legal reason. Okay. Now, there's Section 21, which is going to be abolished at some stage. That's the no fault, and that is a mandatory ground for possession. Or you have to use one of the grounds for possession, which is set out in Schedule 2 of the Housing Act 1988. And there are a lot of grounds for possession, and they're divided into two types. There's mandatory grounds and there's discretionary grounds. If you use a mandatory ground and you prove it, so if there are rent arrears of over eight weeks, 2 months, and you're able to prove that to the satisfaction of the judge is not allowed to deny your order for possession. He's got to make it. And he can't delay the possession in normal circumstances, not now. In normal circumstances, he can't delay the possession for more than 6 weeks. Okay. If you use one of the discretionary grounds for possession, the judge has a discretion whether he grants it or not, which opens the window for the tenant to defend, which means that you're probably going to be faced with a contested case. You're going to have tenants instructing solicitors. They may be eligible for legal aid. It's going to be very expensive. And at the end of the day, even if you prove your case, you may still not get possession. So personally, I would never bring a claim for possession under a discretionary ground unless it's so appalling that no right mind. I mean, if the tenant is actually knocking the walls down of the property, you would probably be able to get an injunction and probably on the back of that, a court order for possession. But I mean, anything short of that, particularly now when we've got COVID, I frankly, I wouldn't bother. I'd go for rent arrears or Section 21. Those are the two main ways that you get possession.
Okay, the next question. Sean is concerned about EICRs. Will there be a tolerance over the fact that we will miss the deadline of the 1st of April due to electricians being inundated?
There may be. It depends what your local authority officer feels like, what he's had for breakfast, and what the department feel about it. But what I would suggest you do is you keep very careful records, because if you've got a series, I mean, perhaps keep a property diary. If you've got a series of records where you record that you've tried to find an electrician, or that if you've got an electrician, you've tried to get access and the tenant hasn't allowed you access, write it all down and record it, because if they do bring a claim against you, I think it's strict liability, but it may be that the court would be sort of forbearing and perhaps give you a small fine or something. I don't know the details of the enforcement of those regulations, but you're more likely to get off if you've got evidence to prove that that you've done your best. Yep. So try and get a letter from or an email from all the electricians that you've contacted saying that they're really busy and sorry mate, they can't come round, and then put that all on your file so that you can prove that you really tried. And look, the trouble is though, you see, people have known that these regulations have been coming for a long time, So I think some of the authorities will say, yeah, you might not have been able to get an electrician in the past 6 months, but hey, mate, you've known these regulations have been coming for quite a few years. Why didn't you get it done earlier? That may be their attitude. I don't know.
I think the other thing, guys, is if I mean the biggest excuse, we know what the biggest excuse is going to be of any landlord. It's going to be, well, I tried to get an electrician, but they're all too busy because of COVID. We couldn't get in, etc., etc., etc. I think provided you've got your EICR inspection in and dated, you've got evidential proof of the fact that the electrician will turn up at some stage to do it. That will be as far as you can possibly take it, because you know what local authorities are like. It's all down to how busy they are. As you know, sad to say that Tessa's absolutely right. It all depends on which side they get out of bed in the morning. A lot of local authority officers. So just be careful, but you need to do whatever you can to prove the fact that you have at least made the best attempt you possibly could under the circumstances. And when they said that they were going to come in, yes, okay, nobody ever thought that we would have 12 months of that we've just had. So you might get away with it, but everybody's using that as an excuse, right? Lenders are using it as an excuse. Solicitors use it as an excuse. Mortgage brokers are using it as an excuse, Mr. Gray. Yeah, I know. So yeah, you can only go so far.
You also have to remember that these rules are 1st of April for tenancies that are ongoing. The rules already come in for new tenancies last October.
Yeah. But do keep records. On the Landlord Law blog, there is a post which is linked from the home page, which is specifically about record keeping. If you do have to go to court or there's any sort of legal process, judges and magistrates and that, they decide things on evidence. So it's really important that you have evidence. I can't emphasize that enough. I mean, not just for this, but for anything. You know, I mean, if you go and do an inspection of a property and you find that the tenants are leaving the bicycles in the fire escapes, you know, you need to tell them that they must move the bicycles from the fire escape. When you get back, you need to do them a letter saying, when I went round there for the inspection, I saw bicycles in the fire escape. Can you please move them? And then, you know, you need to go back and check. So when the local authority officer goes round and inspects it and he comes to you and he says, look, I visited that property and you're allowing your tenants to block up the fire escapes, then you can prevent a claim being brought against you by bringing out all the evidence that you've shown that you've told the tenants not to do it. You know, that sort of thing. It's absolutely critical that you're able to prove things, because the authorities are tending to enforce more and more.
A couple of other things, guys. Bear in mind that straight away this will form now part of well, I mean, I'm assuming anyway, I'm guessing this, David will probably know better than with his connections than I do actually, will immediately form part of HHSRS, won't it, David?
Yes, it will. Yes. Yeah. And remember that in HMOs, it was a requirement to have an EICR before you let anyway. This new legislation is just for family rental.
Yeah. And the other thing, guys, is the fact that as much as we might not like the idea of it, right, and generally they're not expensive, providing they don't find anything that is really untoward. And if they do, and it costs you extra money, right, it's money well spent, because at least then you can sleep in your bed at night instead of having to worry about whether or not one of your buy-to-lets is going to go up in flames with someone in it, right? Yeah. That's how important this is.
There's a question asked on here about an EICR that was done 4 months ago in an HMO, and there were observations. It depends what the observations were. So if the certificate has been granted and it passed, but it comes with warnings, you're okay. You can have the work done. And the warnings come in 3 elements. There's C1, C2, and C3. And you'll have to forgive me, I'm not an electrician, but 1 is a warning. C2 is the sort of middle ground, which means you need to deal with this, but you've got time to do it. And then the 3rd one is this system is dangerous and you although you've got an EICR, it has failed. So if you get a pass, you're okay. That's sufficient. But if you get one that's failed with a lot of very dangerous elements, or just one dangerous element, then of course you have to have that done before anyone can go in the property. So just remember that. So you're looking for C1. Somebody's put up there. Yeah, that's life-threatening. Copper showing. It can be a number of things. So I mean, I've got an EICR that's got some C3s on it, and that's fine. It just means that there are some warnings, but it still passes the certificate.
There you go. And one of my students, Ben, bless him, has given you all the information that you need.
He has indeed.
Yeah. Well done, Ben. You've been taught well. Okay, guys. Right. So what I'd like you to do now is to give Tessa a virtual round of applause. From my point of view, Tessa, thank you so much for coming on. It's been an absolute honour for us to have you with us. Guys, if anybody is interested in finding out more about what you should and what you shouldn't be doing, what your rights are, what the legal requirements are, as I said, that I think the thing that tipped it over the edge for me with Tessa was just how much information there was on Landlord Law website. And that is just so important, and it is a really, really good website. I think it's brilliant, and I don't say that about many websites, but you know, it really is. So Tessa, thank you very much. We'll speak in the next few days about what we're going to do. What I'm also going to do, as I said, I will send out the Jeanette will. Send out the PDF of the presentation, but yeah, it's well worth joining, because it is a great resource to have. Yeah.
Do you mind if I sort of fade out now?
No, okay. Yeah, the only other thing I was going to say about Tessa is don't wait to use her, right? Don't wait to get the information from her until you absolutely desperately need it. Yeah, because by then it will be too late.
I mean, one of the things that the forum is very useful for is I got a lot of people asking me quick questions about things. You know, if there's something that bothers you and you're not really quite sure what the answer is, but you don't particularly want to go and instruct a solicitor, you know, you can just pop a question on there and I'll go in and answer it. And I usually do very short answers and sort of link out to other stuff on the site. So I know people find that very useful. But I shall slide off now and have another cup of tea.
Thank you very much.
Bye-bye, everyone.
Bye-bye. Bye-bye.
Bye. Thanks, Tessa.
Right.
Before we go on to Wayne, there is a question here about somebody who's got an HMO and they want to change the lounge into a bedroom. Does it need change of use? The answer is no, it doesn't. But if that is increasing the tenancy requirements to say from 4 to 5 or from 6 to 7, so you've got an increasing number of tenants, it may affect the licensing conditions, or it may even affect the planning conditions. So in order to answer that more fully, we definitely need more information.
And it will certainly affect your insurance.
And it's certainly affecting insurance, yeah.
Okay. Right, can't see you. Where's Mr. Gray? Oh, there he is, covered up by the chat box. Right, Wayne, I am going to make you, or did I make you a co-host? I don't know.
No, I don't think you did, Barry.
No,
it's offering.
I'm going to make you a co-host so you can use you do your own presentation, Matt.
You can do that anyway. I allowed multiple users.
All right.
Alrighty, well, let me share my screen. Am I showing the right screen?
You are indeed.
You are.
You are.
And you can see the presentation, not yet perfect.
Absolutely.
Hey guys, it's fascinating what Tessa was saying. In fact, I live in Swindon, and although it's not the most salubrious of towns, I won't kid you, there were 5 cannabis factories found in the last week alone in Swindon. In fact, we live in reasonably nice street, all privately owned houses. The house opposite, which is probably the only one that's rented in the street, nobody, unbeknown to anybody in the street, and it's a really nosy neighbour type street. We've got a WhatsApp between everyone in the street, 55 people in the WhatsApp group. Not a single one of us knew there was a cannabis factory or cannabis kind of farm, a house directly opposite ours. Not a single one of us knew for a year and a half, and until the police turned up and raided the place. It's incredible, really. But yeah, most of you, I think, know me and know who we are, but I'll for those of you that don't, I'll do a whistle-stop tour of who I am and who DMI Finance are. So I'm the MD. I've been at DMI Finance for 15 years. We're a very specialist, investor-focused mortgage brokerage.
Wayne?
Yes.
Is it possible you could sit a bit closer to the microphone, because
I can sit as close as you want. Can you hear me now?
Having a little bit of a problem hearing you. It's
sorry, can you hear me better?
A little bit echoey. Yeah, that's much better.
Perfect. Yeah, so most of you, I think, know who I am and who DMI Finance is. We've obviously caught up with most of you for the last few months. But for those of you that don't, I'll do a whistle-stop tour of who we are. We're a very specialist mortgage broker focusing on property investors, landlords, essentially. We have vast industry knowledge. We've been trading for 20 years, and investment has been our kind of main focus. So, we work with some very vanilla lenders, and we work with very niche lenders. We work with effectively all lenders in the market that all work and operate with a broker. We arrange finance for all types of investment properties, be it buy-to-lets, HMOs, multi-unit freehold and leasehold blocks, commercial, bridging finance, development, conversion. And we work with clients, both UK residents, foreign citizens, expats, foreign citizens living abroad, whoever it is. If they're buying something, some property or some land in the UK, then I'm pretty certain that we can assist. So what I thought I'd do today is, and I don't know how we're pressed for time, Barry. How long do I have? 20 minutes?
How long do you want?
20 minutes, something like that? 25 minutes?
20 minutes. Yeah, we can do 20 minutes.
Okay. So my intention is, as I mentioned last time, is to go through how a lender assesses how much you can raise in terms of how far the rent will stretch. But very quickly, I'll just go through some mortgage market update news for you. Most significantly, I guess, change since we last spoke was residential mortgage loan to values. They've increased back to 95% with a large number of lenders. They were hit quite heavily following COVID, and they're at 95% with a number of lenders now for both first-time buyers and home movers. The number of buy-to-let products has increased for first-time landlords. There was some data out only this week by Money Facts magazine stating that around 65% of buy-to-let mortgage products in the market now are available for novice landlords. So perhaps someone that owns their own home but doesn't own any investment properties yet. They're on their first purchase. So that's over 1,300 products in theory available to novice first-time landlords. There have been some reasonably significant criteria changes. Most significantly, I guess, is that we've seen the mortgage lender and Precise Mortgages temporarily increase their minimum loan size to £75,000. So some of you would have used those lenders in the past. Some of you will know that their minimum purchase price used to be £50,000. Now their minimum loans increased to 75, effectively meaning their minimum purchase price is £100,000. So it's effectively doubled. It's a temporary measure. It's a shame that we've lost two lenders at the bottom end of the market or the lower end of the market, but there are still a number of lenders willing to lend on 50, 60,000 pound purchases. So, we're not out yet. Land Bay, very well-known lender, they have taken the decision to move into the trading company space. So almost all buy-to-let lenders, you'll be aware, that will generally want the limited company to be an SPV, a vehicle set up purely for the purposes of buy, sell, and let investment property. There are now, alongside Land Bay, and including Land Bay, a number of lenders that will enter trading companies. So if you already have a company that's set up that you want to buy properties in, there are lenders that will entertain that. Certainly, you'll be looking at a smaller pool of lenders, but it's something to note. Interbay Commercial have widened their appetite for commercial premises. So it was something, again, outbreak of COVID knocked commercial funding on its head quite significantly. Interbay pulled out of the commercial sphere. They then came back into the semi-commercial sphere, taking essentially only rent from the residential element. They're now back in the commercial sphere alone, and they're happy now to lend on properties such as takeaways and some of the commercial stock that they weren't willing to lend on previously are being reintroduced. Interestingly, as Tessa alluded to earlier today, energy efficiency EPC ratings, perhaps there's going to be some changes in the requirements for buy-to-let properties, with EPCs moving up to a higher grade of EPC in the future. You've got a number of lenders, including Precise this week, that have introduced a new range of products specifically for energy efficient properties. So Precise, Paragon have brought out this specific product range. It's for properties with an EPC of an A to a C, but their select rates, they're priced reasonably keenly. They're for up to 80% loan to value. So it's just a sweet spot that they're trying to carve out. I think foundation home loans offer something similar. And then I guess last but not least on the kind of update focus here is that Kensington Mortgages have increased their minimum loan to, or maximum loan to value rather, to 85% on buy-to-lets for both personal name and a limited company. Pretty horrific rates in truth. I mean, they're not something that you would go for as a long-term proposition for a great period of time. But if it is that you think you're getting a good deal and you can get it at 80% or 85% now, and in 2 years' time remortgage it and drop down to a more attractive product, then it's probably worthwhile doing. I think their rates for personal name are around about 5.3%, and in company name at 85%, just shy of 6%. So as I say, they're not market leading by any stretch of the imagination. They're probably not a product that you necessarily want to take forward on the vast majority of your properties. Nor could you, but it does serve a purpose, and that's why I've put it there. A lot of people ask us how rent cover is assessed and how a lender assesses how much the applicant can borrow and the property will achieve. Now, the long and the short is that it doesn't really come into applicants' field of vision when they're buying lower value, high yielding properties, because effectively whatever a lender stresses the rent at, it probably doesn't make much of a difference. If they wanted to see 200% cover on the rent on a lower value, high yielding property, it's always going to stretch. But some of you may have, and I'd say probably will have, been impacted and thought that you've got legacy buy-to-lets, historic properties, or properties that you used to reside in, London or southeast properties that, you know, if you look at lenders' basic rental cover requirements, just won't enable you to raise the amount that you want to borrow. Well, the reality is there are some niche elements that will enable you to actually borrow far more on a higher value, lower yielding property than you may well think you can. So essentially, what do lenders want to ensure when they're assessing the rental income? Well, they want to make sure that you can pay your tax and that the property is going to remain a viable profit-making enterprise, and they want to see that you can cover any potential rent voids. So typically they'll want to see that the rent covers the mortgage payment at a certain threshold. Now, there are multiple calculations, and the three kind of main points to understand when they're assessing how much they'll want to see in terms of rent, and the calculation that they'll employ is the tax status of the applicant. So are they a basic rate taxpayer? Are they a higher rate taxpayer or a limited company? They want to get an understanding of the mortgage term, and that's probably the primary point here. Are you borrowing on a 2-year fixed, a 2-year variable, or a 5-year fixed, which lenders can employ a much more favourable rent recovery requirement on? And what type of property you're buying? Are you buying a single dwelling, an HMO, or multi-unit? Now, as I say, there's really, they're the 3 points that a lender will take into consideration. Now, there's the basic formula that a lender would employ. And essentially, that is to say that a lender will want to see if you're a basic rate taxpayer or buying a property in a company name, they want to see that the rent that the property achieves covers 125%. And I'll do some examples in a minute, so don't focus too hard. But essentially, I want to see that the rent for a basic rate taxpayer or limited company covers 125% of the mortgage payment, assuming that the mortgage was at a notional rate of 5.5%. Now, if you're buying a property and you're a higher rate taxpayer and you're not buying it, and contrary to what I've written here, my apologies, that shouldn't say limited companies, it's if you're a higher rate taxpayer solely, then they'll want to see that the rent covers 145% at 5.5%. So to put that into perspective, on a typical product, they'll look at the annual rent, they'll divide it by that notional rate of 5.5%. And if you're a basic rate taxpayer or a limited company, they'll divide that figure by 125% to calculate the maximum loan that you can achieve on that property. So to put that into perspective, let's say you have a rental income of £500 per month. £500 per month is an annual rent of £6,000. So we get the £6,000 and we divide that by 5.5%. And we divide that figure rather by 125% to get the stress. And that will populate the maximum loan that rent is likely to achieve and likely to enable you to borrow if you're a basic rate taxpayer or a limited company. So a maximum loan of £87,000 for every £500 rent a property achieves to a basic rate taxpayer or a limited company. Now, if you're a higher rate taxpayer, then unfortunately it's more stringent. And as I will say, remove limited company from the second line. That shouldn't be there. If you're a higher rate taxpayer, then they'll want to see that the rent covers at 145% cover. So you're going to get the annual rent, you're going to get the 5.5% notional rate that the lenders take into consideration. And the whole idea of this is, it was all brought about in 2017, early 2017, due to the Section 24 mortgage interest relief changes. Prior to that, whether you were a higher rate taxpayer, whether you were buying in a company, whether you were a lower rate taxpayer, effectively, they wanted to see that the rent covered at 125%, assuming a 5% interest rate. And that went all out the window. And now it's made it very difficult for our clients to understand, okay, well, what rent do I need to achieve on this property? Or what can I borrow? Now, for a higher rate taxpayer, as we established on the last screen, you get the annual rent, 5.5, divide that by 5.5%, that notional rate, and divide it by 145%, will give you a maximum loan. So we'll take the same figures, £500 a month, that's £6,000 per annum. We divide that by that same 5.5%. This time we're dividing it by 145% because that applicant's being taxed more, properties perhaps less tax efficient in a lender's eyes for them to own that property, and therefore they want them to lend or they want to loan them less, which will mean a maximum loan in that instance of £75,000 for every £500 rent, meaning that a higher rate taxpayer buying a property, the same property or renting for the same amount, will be able to achieve, in theory, £12,000 less than a basic rate taxpayer or a limited company. I hope that makes some sense. Now, the key of me explaining this is A, so you get an understanding of how lenders will carry out their basic calculations, but more so to highlight some of the strategic ways that you can increase how much you can borrow on a given rent. And ultimately, you want to make sure the property is profitable, but I'd argue that you might have some background properties that will see some significant capital appreciation. They might not have a strong yield, but they rent well. It's your own home. You've got a previous home. You've got an emotional attachment to it, whatever it might well be. And you want to keep it, but you want to leverage against them. In those circumstances, what can you do? Well, as you'll see from the previous slides, whether you're a basic rate taxpayer or a limited company borrower, or a higher rate taxpayer, the maximum loan available to you may fall short of the borrowing that you require. So, what ways are there to increase that borrowing? Well, there are some lenders that sit outside of the PRA regulations, the Prudential Regulatory Authority regulations that govern how a lender can calculate how much they can lend you. So there are a couple of lenders that sit outside of the PRA regulations, meaning that irrespective of whether you're buying a property as a basic rate taxpayer, whether you're buying a property in a company name, or you're buying it in as a higher rate taxpayer, they will only want to see that the rent covers at 125% of that notional rate of 5%. There are also ways to increase the level of borrowing by taking into consideration some of your background income. So a number of lenders, depending on what level of background income you have, may well do what's known as top slicing. So I said, okay, well, we'll take your background income into consideration. On that property, you're looking for £85,000. You're a higher rate taxpayer, and it only lets for £450. And it's highly unlikely to be a typical scenario, but you catch my drift. We're £50 short of where we needed to be. Well, okay, these lenders will say, well, we can see that if it came to it and the rate was 5.5%, that you would be able to substitute the £50 a month that you're not getting in rent with your background income. And there are lenders that will take that into consideration. So despite the rent not meeting their rental cover requirements, they will lend you the amount that you want. And the third and most obvious way is in securing a 5-year fixed rate. And some of you may have, your existing brokers, come up against this already, unbeknown to you. They may have come back to you and said, okay, the rent doesn't stretch on any other product, therefore we're outlining 5-year fixed rates to you. And the reason that would be is because lenders are not required to consider that 5.5% notional rate if they're lending on a 5-year fixed, and they can lend at something much, much lower. Now that could be, they could base their calculations on 5% or 4.5% or 4%, but it could be as low as the actual interest rate that you're going to pay. So if I do an illustration here, so you're a basic rate taxpayer or a limited company securing a 5-year fixed rate, as we've established before, that's, I think we said £85,000 for every £500 rent, say, for example. If it is, though, that it's a 5-year fixed, then we can disregard that 5.5% rate, and we can calculate it on the annual rent, divide that by the rate that you're borrowing at, which, for argument's sake, in this illustration is 3.5%, and divide that by that 125% cover, it will get the maximum loan. And that maximum loan will be far, far higher than they would have lent based on that notional rate of 5.5%. So again, £500 a month rent, 600 or £6,000 rather rent per annum. The difference is that £6,000 divided by 3.5% is a much higher number than £6,000 at 5.5%. When we divide that figure by 125%, we're looking at a loan then of £137,000 that would be available to a basic rate taxpayer on a 5-year pay rate product. And in fact, it may be even cheaper than that, because you may find a rate lower than 3.5%, in which case you may be able to borrow that little bit more. Now, ultimately, bear in mind from this, you can't ever borrow any more than a set percentage. This is the calculation that we're getting the rent, and it's telling us how much we can borrow, but that's always going to be capped and brought back down, perhaps, in many instances, by the loan to value. So a lender's never going to lend more than 80% or 85% or 75% of that £100,000 purchase, even if the rent would allow you to borrow 137. It doesn't work that way. But as I say, this is particularly useful for those people that have these legacy buy-to-lets that are now used to the kind of more stringent calculations, understood incorrectly that they wouldn't be able to capitalise against those background properties. And it's to say that absolutely you can. It's all about strategy. It's all about making sure that we choose the right product with the right lender. And ultimately, that might not be the cheapest lender, but it's not what it costs you. It's where it puts you. It's what it makes you. But if you look at that kind of last paragraph there, that's enabling a basic rate taxpayer or limited company to raise an additional £49,000 or more on a 5-year fixed, compared to a typical 2-year fixed. It really is a significant difference taking perhaps a 5-year fixed over a 2-year fixed. Headline interest rates, very little change in truth. The 2-year fixed rate has been the cheapest 2-year fixed rate on the market since, I think, the first NPN meeting we did. It's a product at 75%, 1.59% in personal names, TMW. The 2-year limited company and the 2-year HMO products are still the same as they were last month and possibly a month before. 2 very attractive rates offered by Precise. 5-year fixed in personal names has dropped. I think last time it was around about 2.04, so it's dropped down to 1.99 with TSB. And then we've got a couple of rates here. So I think the 5-year fixed at 3.34 for limited companies is with a if I recall correctly, it's with a new lender called Molo. So Molo, a relatively new entrant, digital type lender, not comfortable with large portfolio landlords just yet, but they are quite keen to lend to smaller non-portfolio landlords. So that's at 3.34. And then a 5-year fixed rate here at 3.59, I think is the cheapest HMO or multi-unit freehold block at 75%. So I hope that has made some sense for everyone. I tried to, I perhaps skimmed through that pretty quickly, but I know it's being recorded and you can all have a copy of the presentation if you'd like. But I think it's useful. Ultimately, we'll do all of that behind the scenes. You tell us the rent, you tell us what you're buying a property for, you tell us what it's worth, and we'll calculate it and kind of spurt out the relevant products that meet your requirements or that enable you to achieve the borrowing that you're looking for. But it's useful for you to have that information so you can sit there with a calculation and say, okay, am I going to be on that rent? It makes sense to me. I'm happy with the rent, but can I get the money back out once I've completed my refurb, or that legacy buy-to-let? Can I, that I haven't touched for many years because I didn't think I could borrow much more money. Can I borrow more money? The answer most probably is yes.
Brilliant. Brilliant. 22 minutes.
22?
Yeah. No, sorry, 20 minutes. 20 minutes. Bang on.
Well, look at that.
20 minutes you asked for. But you can't do that again.
I probably can't, no, absolutely.
Thanks a lot, mate. Really appreciate that.
That makes sense.
Yeah, absolutely. Brilliant.
Good.
Okay. Before we say goodnight to you guys, I need to hand you over to the administration department because she wants to say something. So let me think.
No, I just have to unmute myself.
Oh, there you are. Oh, there. Hello.
Hello.
Hello. All right.
Hi, everyone. Hope you're all having a wonderful time this evening. Yes, thank you. Everybody give Wayne a massive round of applause.
Oh, we got to. Yeah, all right then.
Yes.
Yeah.
Come on, we love Wayne. Okay, so hello everyone. Just a couple of things before we leave. We obviously have some fantastic numbers coming to this network event, but we want more. Because the more people we got, the better the quality of speakers, and the more people sort of learn and get involved in property. So I want to ask you a big favor. Can you take a photograph of what you're doing here this evening, and share it on social media? Not only will it do the network good, but it will also do you good, so that you will be able to allow other people to see that you're taking your property investing seriously. So that was number one. And secondly, in the chats thing, I know that Barry a couple of months ago did say, does anybody want to do any basic numbers, basic training numbers with me? Excuse me. So just put in the chat yes if you're interested in that, because I wasn't sure if there was a lot of people or not many people, or just a rough guide. So put Y or yes in there, just so I can get a rough guide if it's something that people are interested in or not. It wouldn't be, again, everything we try to do here is completely free of charge. Yeah. So okay, so quite a few of you would like to just sit down and go through something. Yeah. Okay, good. Excellent. All right. Well, I will send something out on email. As you know, we've got all your email addresses anyway. So I will send a Zoom link out, and we'll do something on a Saturday or Sunday, something like that, if that sounds okay with everybody. So yeah, take some photographs as well and share it. And that was it. That was all I wanted to say. Thank you very much, guys.
Thank you very much.
Thank you. I can only see Tina. Tina's down there. Hey, Tina. But there's loads of you I know on here. It's really nice to see everybody. Okay, over to you, sweetheart.
Okay, thank you. Oh, there we are. Right. When stop sharing, that's great. Guys, thank you very much for turning up this evening. I hope we got something out of that. Can David and I thank Tessa, because she will see the recording of this. Thank Wayne as always. And I think the biggest virtual round of applause has got to go to Jeanette, because you hardly ever see her, but she sends out all the emails, she does all the Facebook stuff, she sets everything up, she does all the marketing, all the promoting for this, so she really is an absolute diamond in the background. The only thing that David and I do these days is turn up, so everything's done for us, so thank you to her as well.
I will do my best to make sure the recording is up on YouTube by tomorrow lunchtime.
Okay, absolutely brilliant. Okay, guys, so thanks for that. We will see you on the, let's work this out, the 28th of April. And we have got a mystery surprise for you on the 28th of April. Why is it a mystery? Because we haven't got a clue what it's going to be yet. Yeah? But it will be something that you will enjoy, I am absolutely sure.
Wayne will be there, Barry. Wayne will be there.
Yeah, in his new house. Yeah, again, Yeah. So guys, thanks very much for your time. Have a great Easter holiday period. Biggest thing, right? Look after yourselves, stay safe, and we'll see you in a few weeks' time. Some of you possibly a little bit sooner than that, but other than that, nice to see you all, and take care. Good night. Thank you. It's good night from him, and it's good night from me.
Good night.
I thought you were going to say nice to see you nice. That's what I was waiting for. Cheers, buddy. Have a good night.
Cheers. Thanks, Wayne.
Bye, Wayne. Good night. I'll speak to you soon.
Cheers, John. Absolutely. Good.
Yeah,
chat.
I do need to talk to you about some things, but as my message said, my old mum had a nasty fall a few weeks back.
Oh, I'm sorry.
I've been looking. She's with my brother at the moment, but I've been looking after her, and it's taken so much of my time.
Of course.
So,
no, that's terrible news. Well, you know where I am.
I'll give you a call and we'll have a natter.
Sounds good to me. Cheers, John.
Yeah, God bless.
Always a pleasure. Cheers. Good night, all.
Bye.